Judge Piet Koen recusing himself from the former President Jacob Zuma's trial in the High Court sitting in Pietermaritzburg. Now, of course, this is quite a lengthy case, as we've seen, first being indicted in 2005, and yet here we are. The matter still is yet to go on trial. And remember, there was, of course, that time in 2019 when former President Jacob Zuma was seeking to have a stay of prosecution. That bid did not succeed, and then there was, of course, now paving the way for a trial, which we are yet to see. But some seem to think that in April, when this matter finally resumes, we may then have a trial. But we don't even know, as you know, where things stand right now, because even the former President Jacob Zuma's lawyers hinting that they may bring an application for Advocate Billy Downer to be removed from this matter. Remember, that was the contention, especially when you look at what Judge Piet Koen had to say even in his ruling this morning. Let's speak now to Nthabiseng Dubazana, who is a legal analyst. Thank you so much for your time. Judge Piet Koen saying that it's in the interest of justice that another judge should take over this particular case. Your view on that?
Well, considering the reasons that he gave us when he was giving his ruling today, for example, the two applications that were before him, the one requesting the recusal of Billy Downer initially, and then the one dealing with the medical records that were then made public, wherein in both rulings he was favoring the state in that respect, saying that Dr. Zuma and his legal team have not given sufficient evidence for there to have been, one, a recusal of Mr. Downer, and two, that the medical records were not given out in a sense illegally. So now the application that was before him prior to him having this lengthy postponement till today, where he also wanted the practitioners, the legal representatives, to make representations to him or heads of argument, wherein they must decide, or rather give reasons why he should recuse himself from the matter. So from the way that the ruling happened, it is not, from what I can see at least, it doesn't seem like there was any heads of argument that were submitted. He made this decision on his own, saying that of the 14 statements that Dr. Zuma's team had stated before, that he seemed to be siding with one person, which is the state, versus him in all areas of this matter so far. He therefore felt that he needs to recuse himself because the decisions he made in these interlocutory decisions, applications, I beg your pardon, they will influence the outcome of the trial once it actually commences. And
I suppose then, when one was listening to him, giving those particular reasons and what you've just said now, when one looks at the test for bias, there's really not much that you have to prove. A perception is more than enough. And I suppose had he chosen to stay on, this would have been maybe one of the matters that could have then seen this matter go to a higher court.
100%. The attorneys for Dr. Zuma, in the event that he was found guilty, they would have taken this matter on appeal or review, depending on how the outcome, the ruling, how it would have been worded, of course, and say that as a result of the presiding officer's obvious bias, because in the beginning we applied for this and he refused it, we applied for that, he refused it, he did not acknowledge our client's constitutional rights and all of those things. Therefore, it can be seen that he did not apply his mind objectively to the merits of the actual case, and therefore his ruling can be seen as biased, and we want another person to hear this matter.
And then looking at what has happened with this particular matter, I mean, it's been a long time in the making, and you look at the fact that there was even that permanent stay of prosecution application which then did not even become successful. Fast forward to where we are now, a new judge is taking over this particular matter. There are concerns, though, that this may result in a delay and the trial not even sitting, as some anticipate, possibly in April.
I do think that there's a huge chance of this matter not happening. I mean, the trial commencing, the actual merits. Because remember, so far, after the pleadings, which is that of not guilty of the accused persons, nothing much pertaining to the actual case has been dealt with. It has been one application after the other. So one of the reasons that Judge Koen made reference to today was that it is concerning that the prosecutor in this matter before him is now an accused person in a private prosecution. So this aspect, the fact that he voiced it out, is actually quite critical in my opinion, because the attorneys for Jacob Zuma might use that, most likely will use that, come April, and this matter has to sit and say, like, in the ruling where the presiding officer before you, my lord, said that the prosecutor is now an accused in another matter, shouldn't really the court look at that and consider it seriously in order to remove this person here? Because in one case, accused here is complainant in the other one. So, you know, there has to be something that has to be done there. I think that's what we're going to be dealing with in April.
I suppose then that would form the basis, much of the basis of their argument come April, because they've already hinted that this is an application that they intend to bring for him to then be removed from this particular matter. So listening to you, that's likely to be the basis of their argument.
I think so. I think that's how it's going to go. I think the counter argument would probably be from the state, would be that currently it is still an accusation and that Billy Downer and Memon haven't yet been found guilty. There hasn't been any evidence that has been led thus far. It's only been one postponement. And also because, if I'm not mistaken, the application for the Pietermaritzburg to be an accused in this matter, I suppose they're going to join him to this current matter. The one where Mr. Downer and Memon are accused persons, if the intention is to join the Pietermaritzburg to that matter as accused number 3, then that would be another basis whereby the attorneys for the state would say that we are yet to even wait to see this matter go forward because there's still a third accused person who's yet to be joined to the trial.
So then how much of a complication then is this for the NPA? Because you look at the fact that, you know, this matter dates back to even when, you know, Shabir Sheikh had to be put in prison and, you know, Advocate Billy Downer being there as well. And I suppose the NPA trying to say that this is our man for the job. He knows this case inside out. So if we let him go, then it means someone else might have to familiarize themselves with this particular matter. So how much of a complication does this then pose for the NPA?
It's a mess. It's a huge, huge mess. Because if they were to have Dr. Downer removed or be removed from the matter and a new prosecutor take over the matter, like you said, he's been in this matter since around about 99 when this thing was starting out. And as a result, it means that somebody else would have to go through that mountain of evidence and try and familiarize themselves with it. He knows this matter intimately. He knows, he's been sitting down with witnesses, I'm sure, those who are still alive and those who passed since. He knows in detail what is supposed to happen in this matter. So that might be a huge blow for the state in the event that they are forced to have Dr. Downer removed from this matter.
And it really is, you know, quite a pile of documents. I mean, one just thinks about the alleged payments themselves. And when you just page through that, you know, your head, it's really a minefield. So let's see how this one unfolds. Thank you so much for your time, Nthabiseng. Do appreciate it. That is Nthabiseng Dubazana, a legal analyst.